Hi, and welcome to More Human, More Resources, the HR podcast for entrepreneurs. I'm Vicki Brown, your host and CEO of Vidamaneo Enterprises. As a serial entrepreneur, I understand that having the right expert help has been critical to my success. That's why I'm dedicated to telling you, in plain language, what's going on in the world of HR that might impact your business, and what you need to do about it, with real actionable tips to help you master that list of must-dos and grow your leadership muscle. First things first, the information contained in this podcast is provided for general purposes only and is not to be considered legal advice. Your decision to adopt or not adopt any practice or procedure mentioned in this podcast is solely yours, and we bear no responsibility for the outcome. We urge you to always consult legal counsel and other appropriate licensed professionals. And with that, let's get into the show. You're listening to Season 5, Episode 23. You know, when you're hiring your first employee, or even your fifth, it's exciting. You found someone you trust, someone you're ready to bring into your world. So you pull together an offer letter, send it off, and figure the rest is going to sort itself out. But here's the thing. That one document can open the door to a world of legal trouble if you're not careful. Oh, I've seen it happen more than once. Entrepreneurs who thought they were just hiring someone end up tangled in lawsuits, wage claims, or tax problems, not because they meant to do something wrong, but because they didn't realize what they didn't know. So before you hit send on that offer letter, let's walk through 4 of the most common and most expensive mistakes that I see business owners make. First up, job titles aren't just labels. They can trigger real legal risk. It's easy to assign someone a title that sounds right based on what you need. Office manager, marketing director, independent contractor, without realizing that title comes with strings attached. So let's start with employee classifications. If you call someone a manager or give them an exempt sounding title, but they don't actually meet the legal criteria for exempt status, well, you could be on the hook for unpaid overtime, for back wages, and for penalties. The same goes for contractors. Just calling someone a contractor doesn't make them one. If they're working like an employee, reporting to you, using your tools, and not running their own business with other clients, then they're probably misclassified. And that opens up a whole host of issues with taxes, insurance, and labor laws. And here's something I really want to make clear. If you're hiring a true independent contractor, they should not be signing an offer letter. They aren't your employee. They're a separate business. So instead, you need a business-to-business agreement. Something that outlines the scope of work, payment terms, deliverables, and it should look and feel like a vendor contract, not an employment agreement. Next, that vague compensation language, well, that can backfire, and it can backfire fast. You might think phrases like around $60,000 or we'll revisit pay in 6 months give you flexibility, but they actually create confusion, and confusion leads to conflict. Be specific. What's the exact salary? What's the pay schedule? Is there a bonus? And if so, what are the terms? One tip that can save you from future headaches, use the word annualized instead of annual salary. That one word makes a big difference. Annual salary can sound like a guaranteed lump sum. And if that employee leaves or gets terminated early, they may try to claim that you owe them the full amount. Annualized salary makes it clear that the salary is earned over time, not guaranteed in full. Also, be careful about making promises, even informal ones. If you say, we'll do a raise at the 6-month mark, and then don't follow through, well, that can be interpreted as a verbal contract. Only commit to things you're certain you can deliver. Otherwise, you're setting yourself up for a dispute you didn't see coming. Third, at-will employment isn't bulletproof unless it's clearly written. Now, a lot of business owners think at-will employment means they can terminate someone anytime for any reason. And in theory, that's true. But in practice, if your offer letter includes conflicting language, anything that sounds like a promise of continued employment or suggests that there are specific steps required before termination, you may accidentally undermine that at-will status. For example, saying, "We expect this to be a long-term relationship," or "You'll have the opportunity to grow with us." Well, those can sound harmless, but legally, those phrases can be interpreted as guarantees, and if an employee is let go, they may claim that they were promised job security. What you need is a clean, straightforward at-will clause, something like, "Employment with the company is at will," which means either the employee or the company may end the employment relationship at any time with or without cause or advance notice. Now, it doesn't need to be complicated, but it does need to be consistent, and it shouldn't be contradicted anywhere else in that letter or any other documents. And finally, skipping the compliance basics, well, that's still a lawsuit waiting to happen. When you're hiring someone, especially in a crunch, it's tempting to move fast. Send the offer letter, get the signature, and figure out the rest later. But employment law doesn't work that way. The moment someone becomes your employee, certain rules kick in, and missing even one can cost you. For example, you need to complete an I-9 form for every new hire, and you need to do it within 3 days of their start date. Now, some states require wage notices at the time of hire. California and New York, I'm looking at you. You may also need to provide notices about sick leave, workers' comp, or sexual harassment prevention policies, depending on where you're located. And here's the tough part. There's no grace period just because you're a small business. You're expected to know and follow the law, even if you only have one employee. That's why I always recommend setting up a hiring checklist. Even if your team is tiny, the time you spend creating a simple process now will save you hours of stress and thousands in potential penalties down the line. You don't need to overcomplicate it. Just cover the essentials: the offer letter, required notices, tax forms, onboarding paperwork, and compliance deadlines. Hiring someone is a big step, and it should be exciting. But if you skip the details or make assumptions about what you can and can't do, well, you're setting yourself up for problems. So take a beat before you send that offer letter. Make sure the title makes sense. Get clear on compensation. Use solid at-will language. And don't forget the legal basics. Because when you start with clean, compliant practices, you don't just protect your business. You create a foundation of trust and clarity. And that sets the tone for everything that comes next. If you found this information helpful, please leave a review and tell a friend. Thanks for spending the time. Until next week, same time, same place.